Okay, so hi everybody. Welcome to our hands-on workshop. I'm Alana. I work at the Innovation Cluster as the Operations and Events Manager. For those of you who aren't familiar with the Innovation Cluster, we are a not-for-profit organization that works with startups working specifically in technology. But with that being said, all of our events and workshops, such as this one, are open to the public. We are also a part of the Team P2BO group. So some of the organizations you're seeing on your screen right now are part of that group, along with some of our partners. So again, thank you for joining us for this virtual hands-on. Today, we are going to talk about intellectual property with Marcelo Sarkis of Prima IP. So some of the learning objectives today are going to be, what is IP, strategies for securing your own IP, typical costs, and rights during national emergencies. So there will be a Q&A at the end of the presentation. For that to take place, I am going to enable the chat feature in your Zoom session. So you'll be able to type your questions in. So please save them until that happens. There will also be a survey sent out to you after this session via email. So you can tell us what you liked about the session, what you didn't like, and what we can do to improve in the future. So I'm going to hand it over to Marcelo now.
Thank you, Lance, for the cluster, for giving me an opportunity to share once again some facts and some tips with respect to intellectual property. I'm just going to now start going through the slides here. So here's just a disclaimer. The presentation is provided as information only, and it shouldn't be as a substitute for IP advice. You should consult with your IP professional for any specific questions or concerns, as every case has to be dealt with on a fact-by-fact basis. As Alana mentioned, our agenda today is forms of IP, costs associated with that, roadmap for startups, some costly pitfalls, patents during times of crisis, and a summary. Typical forms of IP include patents, trademarks, copyrights, industrial designs, and trade secrets. A patent is the one that I think most everyone knows, maybe a patent and a trademark, but a patent is a government instrument granting you the right to exclude others from making, manufacturing, using, and selling your invention for 20 years from the filing date. In exchange for that monopoly, what is required in the patent application is a complete description of your invention to allow others in the same area of research and development to be able to read what you've done, what you have developed, and then allow them to further develop and advance that technology. The term of a patent, as I stated, is 20 years from the filing date. A patent application, when it is filed, remains unpublished up to 18 months from the filing date. And at 18 months, the application is published or laid open for public viewing. Now, that doesn't mean that the application is granted or issued to patent. It still remains an application, and it remains a published application to, again, allow others to read and see what you've been up to. And perhaps if they see that you've been doing the same thing that perhaps they were thinking about doing in terms of R&D, it allows them now to focus their strategy. A patent is also territorial. There's no such thing as a world patent. Many times I hear people tell me, oh, I have a world patent or I have a PCT patent. There's no such thing as that. You can file for an international application, but what that does is a vehicle to facilitate the filing internationally through one office. It never grants to a patent. So even though you can use that vehicle, the PCT or Patent Cooperation Treaty vehicle, to seek protection in 152 jurisdictions, at a certain time, you will then need to undergo examination in each of those jurisdictions in order to get a grant of your patent in those jurisdictions. Once a patent has expired, it becomes part of the public domain. So the claims are what define the scope of your invention. The claims is the fence around your intellectual property. And once you've met the 20-year term limit, your invention becomes part of the public domain. So in other words, you can't re-seek or renew your patent. After 20 years, it's done. There are 3 basic requirements for you to get a patent on your invention. It has to be useful. So there has to be some functional utility behind it. It has to be inventive. In other words, it can't be obvious. Replacing a nail with a screw and saying that the 2 members that have now been fastened by a screw are fastened longer or remain fastened longer than if you were to fasten them with a nail. Well, that's the inherent property of the helical fastener, which is the screw. So that's something that would be considered obvious. But if in using that screw, physical properties of the 2 members reduced oxidation, let's say, for example, or the rusting of the 2 members now took much longer than if you secured them with a nail, well, that could be something considered unobvious or unexpected. In that case, then it would be considered inventive. And the third requirement, it has to be novel, it has to be new, meaning no one could have done it before. If somebody did it before in Russia or in the US or in China, you're not the original inventor, and therefore you would not be granted a patent. Now, I need to qualify that. You could file a patent application, let's say in Canada, for something that you saw in your travels and you brought back to Canada. But at the point where you then now try to enforce your patent rights by suing others for infringement of your patent, the person who's being sued would hire an intellectual property specialist, and then their job would be to find any and all patents or literature references that disclose the invention that has been patented. And if we can find that, wait a minute, this was actually made in China 5 years ago, we then present that to the court, and then you would lose your patent rights. Your patent would be deemed invalid. And if that's the case, then you wouldn't be entitled to any damages for patent infringement. Actually, it would be reversed, because then the defense would be able to seek remedy for you initiating a legal action on something that was ultimately deemed invalid. So for the definition of an invention, it's any art, process, machine, manufacture, or composition of matter, or any improvements related thereto. We now go to an industrial design. So a patent covers the functional aspect of your intellectual property. An industrial design protects the aesthetic or visual features of shape, configuration, ornamentation of the finished article. And the features of shape and configuration should be non-functional. So in other words, if you have a specific helical pattern on a screw, and because of that pattern, it allows for easier fastening of 2 members, that's functional. So that functional component would be covered in a patent. But if it also looks very unique and very different, that component of the screw would be covered by the industrial design as well. So they're not mutually exclusive. There's a lot of overlap when it comes to patents and industrial designs, specifically when there's a design component to your invention that could be construed as ornamental or aesthetic. A trademark is a government instrument granting you the right to exclude others from using your registered trademark throughout Canada in respect of the goods or wares and services associated with the trademark. Now, a trademark has a life term of 15 years. Unlike a patent, a trademark can be renewed. As long as you're using that trademark, you can seek renewal of that trademark, depending, your business is doing well and you're using it. So for example, Coca-Cola has been around for many, many years. Every 15 years, they're renewing their trademark because they're using it in commerce. What can be covered by registration of a trademark? A word or a number of words, a design, a slogan, combination of any of the above, and also sound. Now, the interesting thing is the first sound mark that was registered in Canada. So sound marks have been around for, I would say, maybe 20, 25 years. But the first sound mark was the MGM Lion's Roar. In the US, sound marks have been registerable much longer than they have been in Canada. Some things that are important if you get a trademark, you register your trademark, is you need to use your trademark. You also need to control the use of your trademark. So let's say, for example, I register, let's say I register this mug here, the trademark Rakuten. I couldn't, but let's say I did. And now I find that Atlanta is starting to sell eyewear using the name Rakuten, and eyewear is part of my list of goods and services. I need to control that use. I need to then enforce my trademark. I need to initiate or send a letter to Atlanta stating that you do not have permission to use my trademark. If I don't do that, it could be construed later on that I was just letting people use it and I wasn't controlling my trademark. It'll be much difficult for you to enforce your trademark if there is evidence to show that you weren't enforcing the use of your mark. You need to identify your trademark. If it's not a registered trademark, it's superscript capital T and capital M following the trademark. If it is registered, capital R within a circle. Remember that a trademark registration is not a domain registration. So many times clients will say, oh, well, I did a nuance search and I got a domain registration, so I'm clear. Absolutely not. Many times people will get domain name registrations. It goes through clear, but it doesn't mean that they will get a trademark registration through. Similarly, with a corporate name registration, a nuance search is done, but that's not a trademark search. Copyright is a government instrument that deals with any literary, dramatic, musical, or artistic work. That includes code, computer code, programming, and that is available. The copyright runs for the life of the author plus 50 years. Although copyright is automatic, so as soon as you write something and that is your own original work, or you draw something or you paint something, you inherently have copyright over that work. But registration of your copyright with the Canadian Intellectual Property Office provides or gives you archive protection and a certificate. So should you ever have to enforce your copyright, you would then be able to present the court with a document to say, well, here's my registration. I took the necessary steps to register my copyright. Here's the date, etc. And then hopefully the opposing party won't have any documentation. So it's important to have that documentation if you are looking to enforce your copyright. You should also properly mark your work. So you can use C within a circle. That doesn't necessarily mean that it's a registered copyright. As I said, copyright is inherent, but you can put that on the bottom of your web pages, on any literary work, on any artistic work. That is your own, and you can say copyright, and then your name, and then the date. Trade secrets, although not a government instrument, is a vehicle that you can use, sorry about that, a vehicle that you can use to keep information confidential that is beneficial to you in business, such as a product or process information or any business information. But the key here is that it has to be kept confidential. And you can keep it confidential through confidentiality or licensing agreements. And as long as you keep it confidential, the term obviously is indefinite, as long as it's kept confidential. Once it's disclosed, it's very difficult to put the cat back in the bag, because it's out there. And the only thing you can do is, for example, let's say I signed a confidentiality agreement with Alana. Alana disclosed to me her process to make reinforced frames for eyewear, and then I disclose it. Well, then Alana would then have the option of suing me for breach of contract. But that's it. Nothing beyond that. Again, once that confidential information is out there, it's out there, which is why it's important to think of the other vehicles, the government instruments that provide some sort of legal relief. So examples of many forms of intellectual property found in one item that you likely carry with you and use frequently is, for example, a smartphone. A patent would, for example, cover the touch screen or the flexible screen. I think now Samsung has that phone that folds, or the screen that folds. I don't know if they perfected it yet or not. Trademark could be the Google Pixel or the iPhone, whatever version we're up to now. An industrial design would cover the raised keyboard. So I was a big fan of the BlackBerry because of the raised keyboard. So that was covered by an industrial design, or the round corners or profile of your device. Copyright could cover the operating systems of your mobile devices. And one thing that we didn't really touch upon, but integrated circuit topographies would cover the topography or the look of the integrated circuitry of your phone. So here's just a summary of intellectual property instruments and the terms associated with each of them. So a patent covers inventions, functionality, utility, 20 years. A trademark covers words, logos, slogans, combinations, sound, 15 years plus, because again, remember, you can renew a trademark. A copyright covers artistic works, including computer coding, life of the author plus 50 years. An industrial design protects the aesthetic aspects of a finished article, so up to 15 years. And a trade secret is the vehicle that you're using is a confidentiality agreement or keeping it confidential, and the term can be indefinite, again, on the presumption that you are able to keep it confidential. We're now going to look at just some strategies in patenting when you're looking to patent your invention. File your patent application before a public disclosure. And the reason we say that is, although Canada and the United States have a 12-month grace period, in other words, if I were to visit Alana at, I can't say the innovation cluster because that's subject to confidentiality, but let's say I were to visit Alana downstairs at Venture North at the coffee shop there at Edison's coffee shop, and I tell Alana, hey, I've come up with a new way to make reinforced eyewear, and this is what I'm doing. I'm coating the arms with a specific organic substrate that causes a specific rigidity, and it's resistant to chemical erosion. Well, that's a public disclosure, and if I've given her enough information to allow someone to be able to use that information and replicate my invention, it's a public disclosure. Even though I've just told it to Alana, I didn't say to her, I'm disclosing this in confidence. And even if I were to say that, I'm disclosing this to you in confidence, but there are other people around, or other people could have been around, that's still considered a public disclosure. So at that time, T equals 0, where you've disclosed publicly, you have up to 12 months in Canada and the US to file a patent application for your invention without your own public disclosure barring you from getting patent protection. Now, for other countries, for example, Japan and the jurisdiction of Europe, they are subject to absolute novelty. And in those jurisdictions, China as well, in those jurisdictions, if you have disclosed publicly anywhere in the world, and then you try to seek and file a patent application in that country, you would be risking that your patent application, A, would either be rejected, or B, if it was granted, it would be invalidated if you try to enforce it because of your prior disclosure, public disclosure. Another strategy to file is if you're an SME or a startup, is to file a provisional patent application in the United States Patent and Trademark Office. The reason we use the US Patent Office is it's when you file it in the US Patent Office, it remains confidential. It's never published. And if you don't do anything with it within 12 months, it just dies at the patent office. Nothing else is going to be done. But you file a provisional application, and sometimes that's a down and dirty application. So if Alana said, I'm going to a trade show tomorrow and I'm going to disclose my new eyewear. Well, now we've got to file something and file it with the patent office quickly before that disclosure. And so we put something together and then we file it. And then hopefully that will cover the essence of Alana's eyewear to then allow her up to a year later to then use that provisional application as a priority claim to file, let's say, a PCT. We talked about the PCT just earlier, the Patent Cooperation Treaty, the international application. So the provisional application gets your foot in the door early on before you have public disclosure. Sorry, I should have turned my phone off. But it gives you that ability to use that provisional application as a priority claim for either filing an international application or filing a domestic application. You could file in the US, you could file in Canada, you can file in any country that you desire. But the key is to get into the patent office early, file before any public disclosure. So as I mentioned, you then file a PCT application. You can file that PCT application in one office. We can file here in Canada. It covers 152 jurisdictions, and you have up to 30 months to then determine whether you actually want to seek protection in any of those 152 jurisdictions. It's not less costly. It's more, it may cost about $5,000 more overall at the end of the day. But the benefit is, the real benefit is it gives you about 30 months to defer significant costs before you look at actual examination costs, etc., in every jurisdiction. It also gives you, when you file a PCT, an examination report where the International Searching Authority will do a search and say, we think this claim should be allowed, or we think this claim shouldn't be allowed, because there is a reference. There's a blog that was published by Alana 2 years ago on how she makes her eyewear frames, how she makes them rigid and resistant to corrosion. Other strategies when you're looking at getting protection for your invention is using the Patent Prosecution Highway Program. So that program allows you to, if your application has been allowed, let's say in the US or in Canada, meaning your claims are good and that they've approved your invention for your patent application, you can then send that report, let's say, to Europe or to the United Kingdom or to Japan or to any country that is part of that PPH program and say, hey, it got passed, it got allowed, it got approved in the US. Please, here are the same claims. please allow them in your jurisdiction. And so it should accelerate the examination in each jurisdiction. Many people think that if you file a patent application, that's enough, you're going to get a patent. Absolutely not. You file your patent application, every country is going to examine those claims. So the PPH is there to facilitate the acceleration of that grant and to keep costs down of the examination process in every other country, facilitating the allowance or the grant of your patents in other jurisdictions. The other vehicle that's available, at least in Canada, it was available in the US, but they shut it down a few years ago, is the Green Fast Track program. So if you have an invention such that it falls under the definition of green technology, and in Canada, the definition is very broad. It's anything that mitigates the impact on the environment. You can then request an accelerated examination of your invention, of your application, sorry. And there's no added cost to that request. So again, something to think about, something for you to talk about with your patent professional. Is the Green Fast Track an option? Is the PPH program an option? Here are some of the associated costs. Again, these are ballparks, and you would have to speak with your IP professional to get into the nitty-gritty. Some are going to cost more, some are going to cost less. The less complicated ones usually cost less. The more complex, complicated ones usually cost more. So we have the government filing fees, and then we have the typical fees, including the professional fees, in the parentheses. So you'll see patent application filing fee together with the process from start to finish. You're looking at about $10,000 to $20,000 for a very simple invention. An industrial design, remember that protects the look of the finished article. You're looking at between $2,000 and $5,000. A trademark for one class, you're looking at between $1,000 and $2,000 and 24 months overall. And copyright, you're looking at about $300 to $500. So this is just a little roadmap for startups. Make sure that you identify and understand the clear use of your trademark and of your technology. Make sure you check all employee agreements that you have. If you're a company and you're starting off, it's very important that you speak with an employment lawyer or an employment professional to get those employee agreements in place. It's very important. You need to set and establish early on who owns what. The last thing you want is you hire an employee, they invent something, they're no longer with you, and now they go and file a patent application for something that they invented while they were an employee. If you have everything in the agreement early on, it'll mitigate problems down the road. And in that same breath, you should create an intellectual property policy early on with respect to your organization. Ensure all your employees and contractors sign agreements relating to IP rights. Who owns what? Again, at the end of the day. You should identify, take an inventory of all potential intellectual property. Now, this is important because in many cases, companies may say, nah, this is not inventive. We shouldn't spend any time protecting this. But that's not the test. The test is whether a person of ordinary skill would consider this to be inventive. And inventors are inherently inventive. They're not people of ordinary skill. So it's very important that you speak with an intellectual property specialist and bounce that idea off of them and say, what do you think of this? I don't think there's merit to it. And then the IP specialist will start to ask questions and dig down to see whether they believe that there's merit to seeking IP protection or not. Have non-disclosure agreements in place or have NDAs in place. That's very important. So just making sure, again, that you're showing your employees, you're showing seasonal employees that you're taking your intellectual property seriously. Prioritize your IP protection. So many startups, they work on a limited budget. So you can't protect everything that you're coming up with. What you need to do is make a list of all the potential intellectual property that you have and prioritize what you're going to protect. You have to be selective. Monitor any usage of your intellectual property by your competitors. It's very important. No one else is going to do that for you. No one else is going to do that for you. So you should be aware of what your competitors are up to. And a very good vehicle is searching the intellectual property databases to see whether your competitors have been filing patent applications or industrial design registrations. And from time to time, reevaluate the whole process, reevaluate. Look at your IP inventory. Look at your IP protocols that you have set in place. Look at your NDAs that you've set in place. Make sure, are you putting signs in your place of business stating that any and all development here belongs to the company and that you're not to take it home and you're not to disclose it to us? As long as you're reinforcing the message, I think it's important. Some costly pitfalls include publicly disclosing your invention prior to filing your patent application. Remember, we talked about Canada and the US having a 1-year grace period. Many jurisdictions don't have that grace period. Think about using name or technology without prior clearance. So that could be very costly. Even in Peterborough, I know several cases years ago where retailers called their store a name thinking that it was clear, and then they were served with a statement of claim. And clearing a name can be about $1,500, $2,000, but defending an initial lawsuit for trademark infringement can be $30,000 to $70,000 to $80,000. So you have to look at the cost analysis. Lack of control of IP use. So again, you're not monitoring your competitors. You're not monitoring, you may perhaps have licensed your technology to people, to individuals, or to corporations. You need to monitor what they're doing with that IP. Are they following the agreement that you have between you and them? Or are they going beyond the bounds of that agreement? If they are, you have to have a talk with them and say, hey, you're doing more than what I actually allowed you to do. It's very important. And don't avoid intellectual property counsel. Many people are of the mind that I can't afford to talk to a patent agent or a patent lawyer. Most patent professionals will talk to you and provide you with a half hour to 45 minutes of free consultation. And most of them are very amenable to establishing some sort of an agreement in terms of a payment agreement or how to deal with questions that you have early on. Here's an industry example that I just want you to have a look at in respect of the importance of looking at intellectual property early on.
Protecting your idea and how you execute your idea, I think, is extremely important. The team that is building Nevex. In one of our earlier ventures, we actually invented what's called network address translation. It's a feature that's in every router sold in the last 12, 15 years. And we were young at the time and green, and therefore we just, we didn't protect it. We didn't have the money to, and we didn't have the experience to. This time around, and what I'd advise everybody to do is when you have a really good idea, make sure that you understand how you want to protect it. There are a number of different options. The ones we've chosen are patenting, just as a defensive measure if nothing else. And even though, actually getting a patent and maintaining a patent is very expensive, starting the process is relatively very cheap. You can get something called a provisional patent, which gives you a priority date on your protection for your ideas. and that can range from a few $100s to a couple of $1,000 per, which should be manageable if your idea is really good. And what that really does is allow you to defer the decision about whether to spend more money patenting your intellectual property. And I think everybody needs to start that way, so that once they see whether the company will work, if they have enough money to spend on it, they can then take the decision to go further and properly protect their ideas.
So that's just one example. My friend on the video said a provisional patent, but again, remember, as I said, there's no such thing as a provisional patent. What there is a provisional patent application that you can file. It never turns into a patent per se. So now we're going to talk about the world that we're living in these days. What do we do with patents during times of crises? So in Canada, on the 25th of March, royal assent was given to an amendment to Section 19 of the Patent Act, and it was part of Bill C-13, entitled An Act Respecting Certain Measures in Response to COVID-19. And in this amendment, it allows the Minister of Health and anyone else named in to apply for the rights to make, construct, use, and sell a patented invention to respond to a national emergency. Now here in this case, the amendment was broad enough to encompass emergencies other than COVID-19. So in this case, they said it's going to be national emergency. And for this case, the right, if you're granted that right, you have up to 1 year from that grant to use that patented invention without fear of infringement. Now, for this amendment, right now, the commissioner has the right to use this until September the 30th, 2020. So right now, the minister will be, or the commissioner will be able to grant these licenses to use up until September 30th, 2020. Now, you may say, well, are they using this and they're not going to pay me for my patented invention? No. So this sort of falls back to what we used to have in Canada very often, which were compulsory licenses, which basically allowed a generic to get a compulsory license for a pharmaceutical product, and then the government would issue an amount to say, okay, generic company, you have to pay the innovator X dollars for the use of their patented invention. And in this case, you can see that this is right out of the act, that the government of Canada and any person authorized under shall pay the patentee any amount that the commissioner considers to be adequate remuneration in the circumstances, taking into account the economic value of the authorization and the extent to which they make, construct, use, and sell the patented invention. Here's some examples of other countries that have initiated or reenacted compulsory licensing. So for example, on March 17th, I think Chile was the first country to step up and adopted a resolution justifying compulsory licenses for vaccine drugs, et cetera, or other technologies for surveillance, detection, and treatment related to COVID-19. March 19th, Israel granted compulsory licenses for importation from a generic company of Calitra. Calitra is sort of like a cocktail that is of drugs that is typically used for HIV indication, but they've found that it boosts the immunity. So that's what they're looking at as well for the indications associated with COVID-19. The day after, Ecuador approved a resolution where the Minister of Health could issue compulsory license relating to technologies associated with COVID-19. So then on the 20th of March, the patentee for Calitra, AbbVie, said that they're not going to enforce their IP rights at this time. So they're working with the world to allow the world to use their patented technology. On the 24th of March, Germany introduced a bill to limit patent rights as well. And the World Health Organization has encouraged the sharing of research in a patent pool relating to COVID-19. So it's good to see that companies are working together to deal with this. There was also a company who also shared their industrial design for a shield mask, and they are sharing it with other manufacturers to allow them to replicate those at this time. Some other historic examples. I don't know if you remember back in 2001, after 9/11, there was a very, very big anthrax scare. At that time, Health Canada ordered ciprofloxacin from the generic manufacturer Apotex because they felt that Bayer, who was the patent holder and only authorized manufacturer in Canada, didn't have adequate supplies should Canada have needed the ciprofloxacin. Fortunately, we didn't need it. And before Apotex could supply the government and Bayer entered into a settlement where Bayer would then say, yes, we're able to provide and we'll supply you with all the ciprofloxacin that you need. Section 19 of the Act before the amendment or the addition of Section 19.4 already allows the government to use patented inventions for public non-commercial use while reimbursing the patentee. But this amendment was just to further add and give the government more powers to allow them to use patented inventions in national emergencies. And in 2007, Brazil issued a compulsory license for HIV treatment. Again, they felt that the demand outweighed more than the supply, and so therefore they issued a compulsory license, and they have been still using that compulsory license to this day. I don't think we'll see compulsory licensing, at least historically, I don't think we'll see that with the US, but there may perhaps be some negotiating with the patentees on costs associated with the drugs, but I don't think we'll see compulsory licensing in the US. COVID-19 and intellectual property. So if you are right now in the middle of a patent application, in the middle of a trademark application, of an industrial design application, many intellectual property offices have extended deadlines due to disruptions of COVID-19. Canada originally extended deadlines up to March 31st, and then I think it was on March 27th, they realized that we're going to be in here a little longer than we thought, so now they're extending deadlines up to April the 30th, 2020. I think that'll be extended out again. Most deadlines are extended, some are not. So for example, remember we talked about that 1-year grace period of public disclosure? They're not extending that because that has nothing to do with the patent office. There's no action related to the patent office. Anything to do with the patent office, such as filing a response, paying a fee, paying a maintenance fee, those are the type of that are extended. But what I would say, if anything, speak with your intellectual property professional to make sure that you are complying with the deadlines. What we're doing at Prima with our clients is we're just working as though these extensions have not been granted. So if a response is due today, if a fee is due today, we're paying it today. We don't want to be relying on everybody filing everything on April the 30th, because then the patent office or the intellectual property office, they're going to be inundated, and then we're going to be waiting a long time to hear back from them. The other recommendation that at least the Canadian Intellectual Property Office has suggested is to use electronic correspondence in case of postal disruption. So for example, the European Patent Office, they're already talking about postal disruption, and therefore they're recommending electronic correspondence where available. So to summarize, understand your intellectual property. It's very important to understand it. Take an inventory of your IP. Strategize. Think about what you want to protect and why you want to protect it. Is there a market? Actually protect your IP. Then monitor your intellectual property. Monitor the actions of others. Reevaluate. Reevaluate every 6 months or every quarter. I meet with my clients every quarter to say, okay, what are you guys doing? What are we looking at? What's in the pipeline? Do we need to protect it, etc.? And hopefully by doing all of those steps, you'll be able to prosper. And you notice my little red S-T-A-R-T-U-P, startup. There's my joke for the day. So now we're going into, so I don't know, Alana, do we have time for the quiz?
Yeah, you do.
All right, so now we're going to do a little quiz, but now my question is, how do I find out who answers it correctly? So maybe we'll just play this by ear. So you've developed a new process and tool for removing contaminants from water. What should you be seeking? A patent, a trademark, a copyright, or an industrial design? Maybe we'll let Alana answer these questions.
Or people can put them in the chat box.
Okay, people can put them in the chat box. So where do I find this chat box?
Hit chat at the bottom.
Oh.
So Jane says patent.
Yep. Good. So I'll let you be the
Sure.
first. So yes, it's a patent. Remember, a patent may be granted for a product, so the contaminant removal tool, the process, method of using the tool, composition, perhaps there's an additive or something that you use in the process, an apparatus, a machine to make the tool, and any improvements to the above. So now you've invented a product and you'd like to post it on a description of the product and how it works on the internet. So what do you do first? You post, then file a patent application, or you file a patent application, then post?
So Sancha Reynolds is saying file then post.
Perfect, yes. Remember, you file, then post, because even though we have a 1-year grace period in Canada and the US, you don't know at the end of the day, excuse me, what your market is, who your market is or what your market is, because what if your market is Japan? What if your market is Europe? You've now essentially barred yourself from protecting yourself in that market by posting on Instagram that you come up with, you know, a new glass frame before you file or seek protection of your invention. So the next question is, you come up with a unique shape for the contaminant removal tool. What should you be seeking? I think a trademark, right?
Paul's saying industrial design.
Yes, very good. Absolutely, industrial design, right? Because industrial design may be granted for the shape, configuration, pattern, ornamentation, or any combination of these. Remember, it's the visual appearance of the product, so the aesthetics of the product. So now you decide to name your contaminant removal tool Crystal Clear. What should you be seeking?
Sancha says trademark.
Yeah, and I think I suppose mouth trademark as well. So yeah, trademarks, it could be a combination of words, sounds, or designs used to distinguish your goods or services in the marketplace. And remember, always do a trademark search before you start using your mark. It's more expensive to change your mark, to pay somebody if you've been sued, than to do a search and get a clearance that you're able to then use the trademark. So now you've come up with your original literature describing the contaminant removal tool and process. What should you be seeking? This literature would go along with maybe on your website or be part of your, it goes in the box that comes with the tool.
So Jane says copyright.
Yes, very good. Copyright registration provides protection for original literary, artistic, dramatic, or musical works and other subject matter known as performances, sound recordings, and communication signals. Summary part 2, again, just to reiterate, excuse me, have an IP protocol in place to ensure your IP is controlled and secure. Once you have an IP policy in place, you should know it. You should know your IP policy. Who owns what? You shouldn't be saying, I don't know. I don't know what my company does. If it's your company, you should know exactly what the IP policy is. Work closely with your internal IP department early on to ensure your IP is fully recognized and protected. In this case, if you're a client of the Innovation Cluster, work with the folks at the Innovation Cluster. They know what they're talking about. They're there to help you. They're not going to lead you down the wrong path. Talk to them. Don't be afraid to talk to them. And engage your IP professional early on in R&D to ensure your IP is fully protected. That's it for me today, folks. Thank you for your patience and thank you for visiting. And again, I hope everyone is staying safe and healthy during this time. Lana, I think you're going to open up questions.
So if anybody has a question, you can put it in the chat box now, and then I'll read them to Marcelo. A fun fact for everybody who's watching right now, if this workshop was taking place in person, those of you who guessed right would probably have chocolate right now, but
yes,
unfortunately we don't.
I get to eat them.
Yeah. So I'm just waiting to see if anybody puts anything in the chat box, Marcelo, and then.
Yep.
Okay, so from
Rose, go ahead.
From Paul Tamlin, what steps can an individual do to minimize patent costs?
It's a very good question. What I tell my clients is work closely with your patent agent. Speak with your patent agent about options, alternate working arrangements. So for example, what I do with my clients is I allow my clients, I invite my clients to come in and be part of the process. I will provide them with basic information on what I'm looking for in order to draft a patent application, because that's the most costly component when you're looking to file a patent application, is getting it drafted, because it has to be a complete description. You have to make sure the claims are covering your invention the way you want. Once that is done, that application can be filed anywhere. You're going to use that application to file in any jurisdiction of interest. If you work closely with your patent agent, that cost should come down. There are other type of individuals where they would say, here's what I think my invention is, here you go, and just, and then you don't hear from them. Those are the cases where it's going to be very costly, okay? So that's what I would suggest is early on, speak with your patent professional, and don't be afraid to speak with more than one patent professional. Speak with 3 or 4. We find that depending on who you speak with, they're much more flexible in terms of fees associated with the costs. And some can provide you with recommendations or suggestions of funding available to help you in covering the costs associated with protection.
Okay, so Brandon is asking, are there any online resources you'd recommend to help lower costs for a utility patent? Example, creating a rough draft, diagrams, etc.
Well, that's a good question. There are a number of resources available. I would start with the Canadian Intellectual Property Office, their website. They have several guides on what they're looking for in terms of patent application. It's very, very basic, but it's a very good start. I would never recommend that you file a patent application on your own unless you have significant experience and that you've worked with a patent agent in the past. The reason being, the wording that you use becomes part of a legal document that when you try to enforce it, the document will be what it was. You have to be very careful in how you describe your invention. So for example, you have a bracket, with a bracket that is a 90-degree bracket. That may be what you're selling. That's great. But I would then make the argument, can it be 80 degrees? Can it be 70 degrees? Would it work at 60 degrees? And if the answer is yes, well then I would then argue range of 60 to 90 degrees. Maybe it would work at 100 degrees, 110 degrees. So you always cover off all the possible variants that your competitor down the street is going to say, oh, they only described a 90 degree or claimed a 90-degree bracket. I can make mine 80 or 70, right? I can make mine 110 or 120. That is what the role of an experienced patent professional will do, is to look at all the possible variants and ranges in order to describe your invention broad enough to capture those potential infringers. So absolutely, as I said, the Canadian Intellectual Property Office has a good guide. You can also look at the uspto.gov, and I can send those to Lana as well after the session to share with you. They also have a good resource.
From Gary, do you have specific services or service packages that you offer clients for initiation and completion of a patent, maintenance of them, recurring fees, and ongoing support of an organization to collect new IP?
So that is something that I would sit and meet with the individual, depending again on what they're looking for and what I'm seeing as the workload associated with it. Absolutely, we're open to sitting down and discussing with individuals how we can work on arriving at a package that would be fair to both parties.
Okay, from Rob, someone currently has a coding software platform being designed with a patent pending PCT application submitted before COVID-19. The designing section has been delayed, obviously. Can one request to extend the 30-month period?
No, not aware of that. So, for example, in Canada, the 30-month period can be pushed out to 42 months, but that's unique to Canada. But what you're telling me is, if I understood it correctly, is you have already filed the PCT application, but you're making improvements or refining the coding component in that application. I think you should speak with your patent agent, because once you file a PCT application, what's filed is filed. It's very difficult to add new subject matter in an application. I highly doubt that you're able to do that. And that's just the way I'm understanding the question. I may be misunderstanding, but that could be something that we could take offline, and I'm happy to speak with you with respect to that.
He also added, what would happen if the project isn't ready after the 30-month period?
I don't understand what would happen if the project isn't ready. So you can file a patent application, you can file a PCT application, and at T equals 30 months, you can still enter national phase in countries of interest. You don't need to have a product. Many people file patent applications and they don't have a product until maybe 10 years down the road. So I don't understand your question.
Okay, so Rob, maybe you'll want to get in contact with Marcelo after this. Jane is asking, where can we find quality examples of how to articulate the useful, novel, and inventive features of an idea or product?
So again, good question. You can look at the World Intellectual Property Office website. There's some general information there. But typically, really, that's something that you would speak with a patent professional. That's what their role is. There are some texts out there that may be useful, but again, some of those texts are very general, and every case has to be dealt with on its merit.
Okay, so Arash is wondering, are the patent databases you referenced in public domain? If so, which ones do you recommend using? Through a simple Google search, looks like there is quite a few out there.
So when you say public domain, I'm assuming you mean, are they free of charge? So most of the government patent databases, for example, Canada, Europe, the US, they're all free. They're all publicly available. And those are the three that I typically use: Canada, US, and Europe, as well as the World Intellectual Property database. I find those to be the most complete. A Google search or Google Patents, I don't recommend. The reason being, Google tends to index their documents differently than others, And I've had instances where a client has come to me, they have a published application, they put it into Google, and it doesn't show up because Google has taken the way that he has written a word in his application as incorrect and has corrected it. And so when he puts in his search term, his word, Google doesn't recognize it, and that doesn't come out. So the Google records aren't complete. I know they're working on completing their library, but it's not complete. So I tend to stay away from Google, at least for that reason. The other reason is if Google tends to capture that data and information, you don't know if somebody's saying, oh, look, Arash is looking for a way to make a new chemical resistant iframe. So I would stick to the government databases. Those are sure bets.
Okay, so there isn't any more questions in the chat box, but Marcelo's email is up on the screen if anybody thinks of anything after the presentation. Again, I just dropped the survey into the chat box, so if you guys wouldn't mind filling that out and letting us know what you thought of the presentation. I do also just want to take a minute to tell you that tomorrow at 12 o'clock, we do have a hands-on marketing strategies for startups during COVID-19 workshop. It is sold out right now, but it is going to be recorded and posted. And we also next Tuesday on the 14th have a hands-on cybersecurity while working from home workshop taking place. All that is on our Eventbrite page as well as our social media. But yeah, so thanks so much for tuning in. This is also recorded, so we'll also be posting it. But yeah, anything else, Marcelo?
No, that's it. I thank you for taking part, and just stay safe and stay healthy, and make sure we're all practicing social distancing and doing what we need to do to flatten the curve.
Thanks, Marcelo.
Thank you, everyone. Have a great day.